Is the government keen at unraveling these people involved in the pension fraud and also considering bringing the syndicate to book?
Well, the process is ongoing, and I will tell you in all sincerity that it was that process that now generated all those things relating to reinstatement. Perhaps maybe the syndicate having trying to use the issue of reinstatement of Maina as so as to overshadow whatever the government is planning to do in terms of investigation and in terms of prosecution of the members of the syndicate.
Mr. Maina was on exile for a long while, and people are wondering, why did you clear him and prevented his arrest?
The issue of clearing, I want to assure you that the Office of the Attorney General has not cleared Maina. And then two, in terms of giving protection to him against arrest, the Office of the Attorney General do not have any instrument of authority at its disposal in terms of providing protection to individuals. But one thing I can assure you, that no immunity is conferred on Maina, and then the Office of the Attorney General, even as at October, has taken steps to make recovery against certain companies and individuals that are directly connected and that are allegedly directly connected with Maina.
Does that suggest in any way that there might be some institutional compromises in relation to the investigation and also the prosecution and the pension scam?
Well, you cannot rule out compromises generally, but one thing that I want to bring to your attention, for example, is as at 2013 and 2014, Maina had cause to go to court severally and obtain a lot of judgment and orders over time. Those judgment and orders were against institutions like EFCC, institutions like immigration, institutions like National Assembly, Senate, institutions like Office of the Inspector General of Police. So ever from 2013, when such judgments and orders started coming Maina's way, there wasn't any attempt by any of these agencies to appeal against those judgments or file any application for stay of execution up to the time in 2015 when this government comes into office. So from 2013, when he started going to court, to 2015, there was nothing on record to establish that there was any attempt to challenge the judgment and orders that were being obtained by Maina.
Now, there have been widespread allegations that the federal government do not obey court orders, and the executors are numerous, from the former National Security Advisor, Mr. Sambo Dasuki, and also the wife of the former president of the country, Mrs. Patience Jonathan. In this process, this administration has bluntly disobeyed court orders.
Well, conclusion as to compliance or obedience to court order is not a conclusion one can readily reach without factoring the processes associated with compliance with the court order into mind. If an order is made, you appeal against the order, for example, and file an application for stay of execution of the order. It will be preemptive for you to jump to the conclusion that there exists disobedience to court order.
Are you bringing in institutional bottlenecks to avert obeying court orders, to avert these court orders?
No. When right exists, I think entitlement to exercise it equally comes into play. You have a constitutional right of appeal against judgment and orders, and then you are entitled as a matter of right to exercise such rights when you feel you are not fairly treated, or when you feel there is need for appeal against those orders. That is one aspect of it. And then again, when there are multiplicity of investigation, that naturally comes into play. You are, for example, charged with fraud, and then along the line, the cases of murder emanates that calls for investigation around your person. The fact that you are granted bail over the charge of fraud does not prevent the institutions or the establishment from taking further investigative steps over murder. And that does not entitle you, does not automatically entitle you to compliance with the order relating to fraud when there exists a pending serious investigation that has to be carried out for the purpose of establishing a case.
Let's quickly look at the anti-corruption posture of this administration. You were a member of the three-man probe panel that investigated the former SGF and the former NIA boss. But the public is worried that even up till this moment, the details of that report hasn't been made public.
This government has demonstrated serious political will of transparency in doing things. And that is the more reason why you have freedom of information in place. Freedom of information, which entitles you to information on request. So the bottom line is there a request for information? Is there denial? My answer is clearly no. There is no request that has been denied, and then the members of the public are entitled to know, and if they are indeed interested in knowing, they have to comply with the requirement of freedom of information. It's not something that you are obliged as a matter of obligation, as a matter of duty to make public in the absence of demand against the background of the Freedom of Information Act.
Now, recall that the biggest criticism of this administration is coming from within when the chairman of the Presidential Advisory Committee Against Corruption said that the anti-corruption team needs to go back to the drawing board to search and scan the Constitution on how to deal with the terrible scourge of corruption. Is this not an indictment?
Well, the process of going back to drawing board for the purpose of enhancement of efficiency of any system, I think, cannot be adjudged an indictment, but I think call for a greater action with a view to achieve greater results. So I do not look at it as an indictment, but I look at it as perhaps maybe the need for taking further steps in terms of enhancing the system as it exists by way of bringing in new ideas, additional consideration that can now reinvigorate the process.
Before we wind down on this conversation now, the issue of the whistleblowing policy. Now it's time to take account of stewardship. It's sad to note that the whistleblower of the $50 billion Ikoyi slush fund is yet to be paid.
The starting point, as it is now, for example, is one, the whistleblower signing an agreement, which we call whistleblower engagement agreement with the federal government, which is done in the office of the Attorney General. Now, when the agreement is signed and then the agencies move to action, when eventually recoveries are made, they are usually lodged into the federal government asset recovery account in the Central Bank of Nigeria. Upon such lodgement, there has to be a request for the payment of the fee from a whistleblower, and then you now attach the request. You equally attach the whistleblower agreement that has been signed and forward same to the central bank and seek for confirmation from the central bank of the lodgement of that amount of money. The central bank will now confirm to you the existence of such amount of money, and then now armed with a copy of the agreement, copy of the letter of request, and then a report from the office, from the central bank to the effect that lodgement had indeed been effected, the office of the Attorney General now process the request for payment to Ministry of Finance, which now had the final mandate to process payment.
The Attorney General of the Federation and the Honorable Minister of Justice, thank you so much for making our time to be part of this episode of Question Time. Thank you very much indeed.
Thank you very much, Mr.